Talking Real, brought to you by the Oklahoma Association of Realtors. I stuttered there for a moment, like I forgot what we were doing. I got caught off guard there, Nabil. This is episode 176. We're back in the studio with your host, Jeff and Nabil. Nabil, how are you today?
I am doing fantastic.
Good.
It was a good 4th of July weekend.
Yeah. Happy Independence Day to everybody. I hope it was a fun and safe weekend for everybody out there.
Mm-hmm. Mm-hmm.
Yeah.
And now back to it.
Back to it.
Yep.
Back in the studio here for another episode. And this week we've had a couple of interesting, I don't know how to couch this, I guess newsworthy items, but they're not really news. I mean, it's a couple of things that have come up in the world of fair housing that I think are noteworthy and worth talking about, because one component we'll talk about towards the end that we've already kind of talked about in the past, but I think is a really interesting development. But another one that we want to start out with is something in the world of fair housing discrimination that doesn't really get talked about, and we haven't talked about it before. And this is something that I think is a really interesting issue that people need to be aware of, particularly in the property management type world. Most specifically in like multifamily situations, like apartment complexes and condos and duplexes and those kinds of things, I think is where it's most likely to come up.
Yeah.
But yeah, I think this is an interesting conversation to have.
Yeah, it definitely was. I mean, when I read this, and I mean, we kind of talked about this a little bit, which we'll talk about again right now. But I was like, oh, is that a thing?
Yeah.
And that's the question that comes to mind, is like, oh, you could do that, after the fact, as you'll see when we go through the scenario.
Yeah. So kind of what we're talking about, enough of the building the anticipation.
The teasing.
Yes. Get a little clickbait in there, make you want to stick around, see what we're talking about. So what we're talking about here is a situation where you're dealing with discrimination after acquisition of the property. Okay, so like post lease, like the lease is already going on, the tenant is already in there, discrimination that occurs after that. And in this case, it's not even direct discrimination by the landlord, but we'll get into that in just a minute, because usually when we talk about discrimination in housing, most of the time what we're talking about is choosing not to lease a property to somebody on the basis of some protected class. Right. We're going to weed them out so that we're not renting to people of a particular race, people of a particular religion, or whatever the case is. We're going to weed them out so we don't lease to them at all.
Right. Kind of like just a barrier to entry for a particular category of people.
Right. In this case, what we're talking about is really a discriminatory housing environment. So you have already leased the property to somebody, and now they're facing discrimination, and the landlord's not doing anything about it.
Which is interesting to think about, that, yeah, this is a living situation issue, right? Because it's a hostile living situation.
Right.
But it's interesting to think about that you can, the landlord is responsible for whatever happens there.
Yeah, exactly. Particularly where there are, common areas, things like that, where, the landlord has some ability to do something about what's happening. And what we're talking about here is a case that came out of the United States Court of Appeals for the 7th Circuit. So this is not something that's been before the United States Supreme Court. This is really settling an issue that was on appeal. So it's been remanded back for some additional proceedings. But I think that this is something that we can all take a really interesting learning piece from, of something that, again, I've not really heard anybody ever talk about this issue in education classes. I've not talked about it in education classes I've done and those kinds of things. So
you will now.
I probably will now, because this is a really unique kind of thing.
Yeah.
So what happened here is you had a lady who she moved into a senior residential community. Okay. So she was a little bit older, senior living area. Her partner had passed away, and she started to endure significant harassment from other residents based on her sexual orientation. Okay. So she moves in, her partner passed away. She's getting severely harassed by other people that are there, not the landlord, but by other tenants in the area. Okay.
And sexual orientation is a protected class.
Well, we'll get there because not directly it isn't, but in this case, yes, it is. I mean, so it is, but it isn't, right? And we'll cover that in a second, because that's actually an interesting issue here as well. That's we've again started to see some evolution of.
Yeah.
And so in this case, she's facing this sexual orientation discrimination. And she actually sought relief from the staff of this senior residential community. And so she made a complaint to them and said, hey, I'm getting harassed here. Like, this is serious.
Makes sense. Who else are you going to go to at that point?
Yeah.
Right.
Exactly. And the staff members actually restricted her access to public areas. And they did kind of do some additional things that probably weren't very good. But one of the claims that was made, and I think this is the one that's the most interesting that we can take away from, is she sued the senior living community under the Fair Housing Act. And her allegation was that it failed to ensure a non-discriminatory living environment. And that's what's interesting here. This is not necessarily their discrimination or anything like that. She didn't sue any of the individual people that were harassing her in this case. This was about this facility, this community, and the owners of it who knew about this issue, didn't do anything about it. And so they were creating essentially a hostile living environment by allowing tenant on tenant harassment, and they didn't do anything about it.
So it's kind of like a hostile environment by proxy.
Right.
Like you have control over it, but you're just kind of letting it go.
Right. And so this case was originally dismissed, and this is why it was appealed. It was dismissed at the trial court level. And so she appealed it up and said, yes, I actually have a claim, right? They're saying you don't have a claim because they didn't actually discriminate against you. They didn't do anything.
It wasn't the landlord doing anything.
Right. And that was really the issue here, right? And so the court looked at this and said that, yes, you can sue the landlord in this case under the Fair Housing Act, and that it does cover particular kinds of post-acquisition discrimination like what she suffered. And what they said is that the plaintiff in this case, the person that was discriminated against, has to show 3 elements for a discriminatory claim, a harassment claim against the landlord. And in this case, what they're saying is it unreasonably interferes with the use and enjoyment of the property, or also referred to as a hostile housing environment under the Fair Housing Act. And the 3 things that have to be proven are that she endured unwelcome harassment based on a protected characteristic. So again, these are the protected classes that we've talked about. And now sexual orientation, traditionally not a protected class. But yeah, we're definitely moving in that direction. In this case, we'll explain that as well. The second thing is that the harassment was severe or pervasive enough to interfere with the terms, conditions, or privileges of her residency or in the provision of services or facilities. So it's not just, some comments that were made, but this was a very pervasive, very severe issue that prevented her from actually the use and enjoyment of the property.
Like it wasn't just an annoyance.
Right.
It was actually affecting her
This
life.
wasn't just a grumpy neighbor who would make improper comments from time to time. No, this was a more pervasive, severe issue. And the third thing is that there is a basis for imputing liability to the defendant, which in this case is the landlord. So you have to be able to connect the landlord to it. And in this case, part of that deals with, well, they were notified about it and they didn't do anything about it. And in many cases probably made it worse.
Right. By like restricting access and whatever it was.
Exactly. So the way they tried to fix it, if that's what was going on, was not correct.
Yeah.
So in this case, the first thing was that you have to prove that it involves a protected class, essentially. And the court noted that discrimination based on sexual orientation qualifies as discrimination based on sex. And sex is a protected class under the Fair Housing Act. We've talked about this in other contexts. This is, for all intents and purposes, sexual orientation is a protected class as a subcategory of discrimination on the basis of sex. Okay. This is established now in employment law. It's for all intents and purposes established in fair housing law. As far as anybody listening to this is concerned, sexual orientation is a protected class, right? Like we're just going to leave it at that. The courts are recognizing it. It is, right? We're just going to say that it is. It's also protected under our code of ethics. Right. So she met that burden. right? So she was able to prove that. And the second thing is that she was able to prove that it was severe and pervasive harassment. This was, again, a major issue. And the third one, and this is really the interesting one, is how did she prove that it was connected, that the landlord could be imputed liability, right? So she had to be able to show that the landlord for some reason had something to do with it.
Right.
And so the court noted that the Fair Housing Act does not set forth a test for landlord liability. So there's no like check the list. So instead, the court reviewed analogous liability under other anti-discrimination statutes, such as Title VII, Title IX. And so kind of using, well, what do other anti-discrimination type statutes, what do they look at? And in this case, established that the Fair Housing Act provides a basis to impute that liability when the landlord had actual knowledge of the severe and pervasive harassment and was deliberately indifferent to it. And that's what was happening here, is that they didn't do anything. And their defense was, well, look, we don't have control over the residents' actions. We can't do anything about
right. They're individuals that make their own choices.
Right. And we don't have any legal control over it. And the court noted that you don't have to have complete control or absolute control over somebody. You do have some control. And based on their knowledge,
you're still a figure or a point of authority in that community.
Right. And in this case, they actually had some legal things they could do. They could have evicted a tenant for harassing other tenants, right? And that was actually in their tenant agreement. They prohibited tenants from directly threatening the health and safety of other individuals or unreasonably interfering with the peaceful use of the residence by other tenants, right? So, similar to how you may have this in a lease for an apartment building, right? That you can't interfere with other people's use of the property.
Right.
So they had that. They had that in their agreement. Yeah, my allergies, man, like, it's crazy. My nose allergen. So they had that in their agreement. They didn't do anything about it, even though they had that. They also, the court noted, they could have updated their tenant handbook to clarify their anti-harassment stance and their provisions, and suspended privileges for other tenants who violated that policy. And they didn't do anything. They didn't do any of this kind of stuff to try to correct it. And so the court said, yeah, so you could theoretically hold them liable. So this has been kicked back to the district court to kind of determine what the next steps are, and how that's going to shake out. But this is a really interesting sort of thing that we, again, like I said, we don't talk about. I've never heard it talked about, that a landlord being responsible for two tenants having some sort of discriminatory action between them when the landlord knew about it, could have done something about it.
So from your point of view, what is, because this is probably a question that everyone's thinking of now, be like, what could the landlord have done? So what is one, I mean, we can all think of like the correct thing the landlord could have done, but what's like the minimum thing you think the landlord could have done not to get in trouble like this?
Yeah, I mean, they
like,
should
what's
have done,
the basic action that you need to take in this situation?
Yeah, I think it depends. Like, it depends on what their policies are. It depends on what the lease says. It depends on what the degree and severity is. The more severe something is, the more severe your reaction should be, right? So I could imagine a scenario where maybe you're the landlord managing an apartment complex, and you've got a tenant, perhaps a single female living by herself, is saying that another tenant is sexually harassing her, making sexually harassing comments, knocking on her door in the middle of the night, things like that, right? Very serious, concerning behavior. In that, like, okay, we might need to evict this person, right? We got to take quick action. We got to do something, because this is a potentially dangerous situation that we're starting to see, right? Versus somebody, you've got a tenant who's making inappropriate comments every once in a while, and they're aware of, well, maybe you don't necessarily evict that person, but you do need to take some other corrective action.
Maybe a stern email would work in that
like
situation.
You would start with something of having warnings of reiteration of what your policy is. This won't be tolerated. Oh, they do it again. Okay, well, here's our next step. We're going to escalate that.
Here's your notice. Be like, you do it again, and you might be out of here.
Exactly. So I think that you need to have that kind of policy set forth. And I think this is the kind of thing that you need to think through. How will you address it, right? The severe case we can understand, right? So perhaps you've got somebody who assaults another tenant through some discriminatory action. Okay, well, we're going to obviously we're going to call the cops and we're going to kick this person out, right?
Right.
I mean, we know what we're going to do in that. But there's obviously a scale here. There's a spectrum of different types of things that could happen. But, I think the takeaways here are that this is something a landlord needs to worry about, right? And this could be, say you do own 2 houses next door to each other, and one tenant, like maybe a minority family, moves in, and the other tenant next door starts doing various types of discriminatory activity against them based on their race, right? Trying to run them off. I mean, these are things that could happen.
Mm-hmm.
That's a real thing that could happen. And how are you as a landlord going to deal with that if the other tenant complains to you?
Right. Because you have control over both properties.
Exactly. Now you're the landlord of both properties and you've got one tenant doing something. So is there something that you should be doing? Right. Well, maybe you should be thinking about that, right? Like how am I going to handle this? Or when that happens, maybe you need to consult an attorney to say, what am I supposed to do in this case? I'm concerned about this. My liability, as well as just this is wrong, right? It's a wrong thing, and we need to be able to address that. So I think that's something that needs to be thought through, is just at least being aware that if this kind of complaint comes in, don't do nothing with it and don't make it worse, right? Like you've got to do something. So that's kind of the takeaway there.
Now, and I think the situation would get a little murkier and more difficult if you didn't have control over the house next door where someone was getting harassed, right? But at that point, you literally don't have any control over. Right. But what if you knew the landlord or the company that operated the other house? Like, what would you? Do you have some sort of like obligation? Maybe morally you do, but
would there be like a legal obligation? Right. Probably less so, because again, you don't have control over that person. And so, or their property or anything along those lines, so I think that there's a spectrum, just like there's a spectrum of different types of discrimination that may occur, and the severity of it and what kind of response you have, those are all factors that kind of play into it. And so you probably don't have a duty at that point to do anything, because you can't. I mean, there's nothing that
there's nothing you can like enforce on that side. Right. But you could let the other landlord know to be like, hey, by the way, this is what's happening.
Yeah, so. Exactly. So there could be at least putting the other landlord on notice, those kinds of things that could occur. So again, this is most likely to occur, I would think, in that communal living type scenario. Like in this case, it was, a senior residential community, an apartment complex, dorms, condos, those kinds of things where you've got people living in closer proximity that you might be more likely to see.
Thought of another question for you.
Okay.
It's a variation of the same thing that we were talking about. What if that neighbor found out who was the landlord of the house that was discriminating or harassing, and they complained to them?
Does maybe, right? So maybe you've got somebody who is not your tenant, but is the next, a tenant next door, right, comes to you and says, hey, your tenant is doing XYZ to me. Maybe you might, right? Because now you're on notice of somebody that the tenant that you have is creating a, if it's a severe situation, a severe harassing situation to other people in the neighborhood, do you have a duty? Maybe. It's hard to say, right? Because this is sort of I don't want to say a new issue, but it's a different kind of issue. So I don't know the answer to that. But certainly I would say in any of these cases where somebody comes to you and there's a property you have control over to some degree, and a tenant of that property is creating a severe and pervasive discriminatory situation for other people, you need to think about, do I do nothing or do I do something? And
probably should do something.
And there's a pretty good chance that if you do nothing, and you're now aware of it, is that going to potentially create additional liability for you? It's certainly a risk. And so, be thinking about how to manage that risk and what kind of things you should be doing.
Nice.
Yeah. So on a similar note, there was something interesting that happened a week or two ago in Oregon. And we talked about love letters on the podcast before. We did a whole episode on them and why they're a problem, and you shouldn't have a client write them, or if a client does write them, you shouldn't submit them. And if you receive one, you shouldn't submit it to your seller.
You should advise them well.
Exactly. Well, so in Oregon, they have actually gone so far as to ban them. And their bill that was just signed into law on June 23rd directs sellers agents to reject any communication other than customary documents in a real estate transaction from buyer to seller as necessary to help the seller avoid selecting a buyer based on a protected class.
So they're just stopping it right there, being like, we're not even going to let this be a potential problem. You just can't do it.
Exactly. They've said that if you, as basically a listing broker, you receive something from the buyer that could cause the seller to potentially select a buyer based on a protected class, you shall not pass that on to the seller. Don't give it to the seller, which I think is great. I mean, again, this is an issue that a real estate transaction is a business transaction. There is no place for these types of pleas of, select me because XYZ, other than the business decision. I mean, that's what it should be. It should be who's got the best offer. I mean, again, look, I know there's a lot of factors that go into it, those kinds of things, but those factors are not based on what their familial status is. It is not based on their race, their color, their religion, any of those things.
Right.
And so anything that could cause a seller to go down that road, that's going to get us in trouble because we have to be their guide. Because if your seller makes a decision on that basis, it's not just your seller that's going to get in trouble. It's going to be you, because you're the expert.
Because you were their guide.
You're the licensed person. You're the expert, those kinds of things. So it's interesting. Oregon's gone so far as to completely ban them. So I just wanted to kind of throw that out there to reiterate. Go back and check out our episode on love letters if you're not really familiar with that topic. NAR has listed out they did an article on love letters and why they're a bad idea. So, again, even in this crazy market, buyers are going to want to do that kind of thing. And so you got to be the one to say, no, we can't do it. And here's why.
Right.
So definitely check that out.
Yeah. And that was episode 143.
There you go.
For anyone that wants to jump back and listen to that.
I thought it was longer ago, but I guess that was actually a while back. That was over half a year. So there you go.
Was it? Yeah, that is. Oh my gosh.
Time flies. So that's all I got, Nabil. What else is on tap?
We have a special guest joining us on this episode.
Yes, we do.
We do. We've got Lisa Weaver zooming in, or be-living in, because, to talk about the Realtor of the Year award.
Yeah.
As we all know, it is application month.
Yep.
Technically June's application month, but the award applications are open till July 30th. And so Lisa Weaver is joining us to talk about the Realtor of the Year award, why it's important, and, why people should nominate either yourself or someone else for this award and all the others.
Perfect. Well, let's just jump in with Lisa Weaver to talk more about Realtor of the Year and other awards and applications.